closed door in his chambers the opportunity to present any evidence they had to show that the couple of $1 billion cost overrun, which, by the way, is not unusual given the size of the project at all, is the result of fraud or criminal fraud. And the judge said, I gave them the opportunity, and the government at the hearing declined to offer any other evidence, nor did they supply any for the judge's personal review. But it's worse, because in the transcript that's now been released, the head of the criminal division for the Department of Justice's U.S. Attorney's Office in D.C., a guy by the name of George A. Masuko-Latayev, told the judge that he...
Did you hear that? A federal prosecutor was asked for evidence, and the answer was basically, we do not have it. That is not a small detail. That is the whole case. According to AP, the sealed transcript shows prosecutors admitted they did not know of fraud or criminal misconduct. Then Judge James Boasberg quashed the subpoenas. Reuters reported the judge wrote, there was no evidence whatsoever that Jerome Powell committed a crime other than displeasing the president. Let that sink in. Because if the Justice Department can open a criminal probe first and hunt for facts later, then no independent institution is safe. Not the Federal Reserve, not the courts, not even basic democratic guardrails. And by the end of this video, you will understand why this fight is not really about construction. It is about pressure, it is about power, and it is about whether evidence still matters in the United States.
Play the clip.
He's building a complex over there that's under his jurisdiction. He started it, and it's out of control. It's billions of dollars for a little building. I could have done that building and made it beautiful for $25 million. $25 million, and it would have been beautiful. Look what I've done at the White House, fixing it up. And I mean, the place was in bad shape. You see the floors and everything. It was in bad shape. I could have made that building beautiful for $25 million.
Here is what they are not telling you. A cost overrun is not proof of fraud. It never was. The public facts are much less dramatic. The Federal Reserve says this project covers 2 historic buildings. Those buildings date back to the 1930s. They had not been fully renovated in decades. In a July 2025 letter, Jerome Powell said the work included asbestos removal, lead cleanup, and replacing ancient systems, electrical, plumbing, HVAC, and fire suppression. Those are not luxury extras. Those are safety basics. The Fed's public project page says cost increases came from higher labor costs, higher materials costs, design changes, and unforeseen conditions including more asbestos than expected, toxic soil contamination, and a higher water table. Now ask yourself one honest question. Where is the criminal act? Where is the kickback? Where is the false invoice? Where is the hidden payment trail? AP reported that when the judge asked what evidence existed, the prosecutor answered, "We do not know at this time." This is the document that changes everything. The judge did not merely slow the case down. He said the government offered no evidence whatsoever. He also said the stated reasons were so thin and unsubstantiated that they looked pretextual. That is courtroom language for, this does not look real. It looks political, and once a federal judge writes that, the spin starts collapsing fast.
Is fed up with public monies that seem to go into a black hole, especially in D.C., where no one is held accountable. One of the age-old tools that all prosecutors have to investigate any crime, including cost overruns, is a grand jury subpoena. Today, however, in Washington, an activist judge has taken that tool away from us by inserting himself and preventing the grand jury from even obtaining, let alone hearing evidence. He has neutered the grand jury's ability to investigate crime. As a result, Jerome...
I believe this is the real heart of the story. Not the building, not the marble, not the headlines. The real issue is power. Reuters reported Trump had repeatedly pushed Powell to cut rates. Reuters also reported Boasberg found a mountain of evidence suggesting the subpoenas were meant to pressure Powell to lower rates or resign. That is a stunning finding. And look at the fallout. Republican Senator Tom Tillis said he would block Fed nominees while this probe stayed open. That means this pressure campaign did not just threaten Fed independence, it also backfired politically. This is outrageous because the grand jury is not supposed to be a political weapon. It is not supposed to be a scare tactic. It is not supposed to become leverage in a fight over interest rates. Every American should know that independent institutions only work when leaders respect limits. The Federal Reserve was designed by Congress to be insulated from raw political pressure. If interest rates become political theater, your mortgage, your savings, and your retirement feel it. This is not abstract. This hits kitchen table economics. Now look at what the Fed publicly said about the project. This is not hidden. It is on the record. The work involved asbestos removal, lead contamination, ancient electrical systems, plumbing, HVAC, fire suppression, structural repairs, and accessibility upgrades. That is a massive renovation footprint. The Fed also says cost increases were driven by labor, materials, design revisions, and unforeseen site conditions. So when politicians reduce all of that to one angry talking point, they are leaving out the most important part, evidence.
Play it.
If there's no Federal Reserve chairman confirmed on May 15th, would you stay on?
So if my successor is not confirmed by the end of my term as chair, I would serve as chair pro tem. That is what the law calls for. That's what we've done on several occasions, including involving me, and it's what we're going to do in this situation. And while I'm at it, on the question whether I will leave while the investigation is ongoing, I have no intention of leaving the board until the investigation is well and truly over, with transparency and finality. And I would refer you to the statement that was in the Fed's brief that you all have seen, and I won't have anything more for you on that. On the question of whether I will...
So here is what we learned. A judge quashed the subpoenas. AP reported the prosecutor admitted there was no known evidence of fraud. Reuters reported the judge said Powell appeared targeted for displeasing the president, and official Fed documents show the renovation had public documented cost drivers. This is not just about Jerome Powell. It is about whether independent institutions can survive political coercion. The Federal Reserve is not above scrutiny, but scrutiny is not harassment, and suspicion is not proof. So the next time you hear someone yell fraud, ask the only question that matters: where is the evidence? Because in this case, when the judge asked for it, the answer was silence. And in a democracy, silence is not enough. That is why this matters. That is why we stay on it. And that is why your voice matters right now.